Good morning, everyone. Welcome to this very cold December day if you're here in Pittsburgh. Boy, this was a rude awakening this morning. I hope everybody, though, is enjoying the holiday season despite the freezing temperatures we've got right at the moment. So today's going to be a little different than we normally do. So for those of you who tune in on a regular basis, usually it's me talking most of the time. This time we've allotted a chunk of time to your questions, whatever they may be. And if you don't have questions, then we all get done early and go to lunch, I guess. And that's okay too. So for those of you who don't know me, I'm Ann Lavelle. I was a partner attorney in a very large firm in downtown Pittsburgh for almost 25 years and practiced exclusively management side labor and employment law. I retired and I'm enjoying my retirement, except on cold days like this when I think I need to move south. And I just knew CTR from my prior life, and they asked me if I would do these compliance webinars, which I do once a month, the second Thursday of the month. And every now and then we do a seminar as well. So welcome. Last month, we talked about the major things in 2024 that had occurred and sort of looked into a crystal ball. I wish I really had a crystal ball to talk about what might be coming up in 2025. We're going to continue that today. And again, we're going to throw the, open up the floor, so to speak, and you can put it, I think it's the chat that works. I'm so terrible with technology. Put any question you might have in there at any time. And if there's questions, we will go through them. It'll be a great learning experience for anybody. It doesn't have to be on the things that we're talking about today. It can be on any topic you want it to be on, and we'll try to handle those questions. So diving right in, we talked about a lot of things that had happened this year. And right after I got done with the seminar last month, this is sort of our outline of where we're going. There was a new twist to the Fair Labor Standards Act, because a court decision came in. And when we talked last time, I said, hey, the salary threshold's going up January 1st again. It had gone up July 1st of 2024, and the courts had refused to block it. And so when we met last time, that was still the case. However, a couple days after the webinar, which is Murphy's Law, a court did weigh in and blocked the change. And I want to spend a little bit of time talking about this. So November 15th, like 3 days after the last webinar, the Texas court, a federal Texas court, blocked the increase retroactively to July 1st for all employers across the entire country. And you might say, well, how does a Texas court have that kind of authority? They do. This has happened before, where a lawsuit has been brought in what is a conservative jurisdiction. And by conservative, I mean one that's more employer friendly. Tends to be Republican. I don't take sides. It's just sort of the way it is. And Texas had nullified a prior increase, and this becomes important, in 2016, if we go back that far, when we had President Trump coming into office for the first time. President Obama had issued an increase with his Department of Labor to the salary threshold. And in 2016, a Texas court had nullified that increase that President Obama's DOL had attempted to put in place. And that decision was on appeal when President Trump came in 2016. And President Trump at that time said, I'm not going to allow the Department of Labor to continue the appeal. We're just going to live with the Texas court's decision to nullify the increase. And we went back to where we are right now, which is the $684 a week as the salary threshold. That history is important because here we are 8 years later. President Biden's DOL issued the increase. It looked like it was going to move forward because no court stopped it before July 1st. And in fact, it did move forward. And now November 15th, we have a court in Texas that says, on second thought, we think this increase is not provided by the regulations or by the Fair Labor Standards Act, the text of the law, and we're nullifying it. President Biden's DOL has appealed this decision. But we have President-elect Trump coming in. If he holds true to form to what he did last 2 election cycles ago, he will not continue the appeal, and we will be back at the 684, which was where we are now, for the remainder of his administration. A couple of things to note here of why this makes it extremely tricky and gives employers a lot of heartburn, because employers were operating for about 4 or 5 months under a law that said you had to increase the salary basis for exempt employees to $844 a week. Many employers did one of 2 things. They either increased their workers' pay, or they converted people who fell short of that, but made more than 684, which was the prior threshold, and we're now back to that again. They made them non-exempt and started paying them overtime. What do you do if you're one of those employers who either increased the wages, right, the salary from 684 to 844 or somewhere in there, or started paying your employees who made less than 844 overtime, but who were previously exempt? I hope this all makes sense. You really have a couple of options. The first rule of thumb here is you can't retroactively recoup the salary. So if you gave them a raise or you paid them overtime, it is what it is. Going forward, you can make a change because we are now back to the 684 a week and not the 844, at least in Pennsylvania. Some states do have a higher salary threshold, so always check your locality for where your employees are located. But assuming you don't have a state law involved, you can reduce them, if you so choose, back to the 684, assuming they're still meeting the duties test and all of that good stuff to be exempt. While you can do that, I have to tell you, that's going to be a huge morale killer. People live up to their income, so to speak, and to take that away is because of this 3-ring circus, which is what it is, with the courts and the regulations and the different presidents coming in and doing different things, stuff that's so far removed from your employees' ability to control and your ability to control. It's going to be a morale killer for them. If you choose to do that, if you choose to reduce the salary, you have to do it prospectively, and you have to give them notice, right? So if you want to do it, you say, hey, next pay cycle, we start, not retroactively somehow or something like that. Same thing if you've been paying overtime to the folks who were earning between 684 and 844 a week. If you were paying overtime, again, they're not going to be the happiest people. If you tell them, hey, you're now exempt again because you meet the duties test and you're now on the right salary threshold again, but you can do that prospectively if you want. You may see some fallout over that of not being wanting to work more than 40 hours and being unhappy and all of that good stuff, but you are capable of doing that. So we have a very convoluted FLSA twist here at the end of the year that leaves employers having to make business decisions as to whether they're going to try to unring a bell that they put in place on July 1st. The other thing is, if somehow President-elect Trump decides to move forward with the appeal, which most commentators think he's not going to based on 8 years ago, then you've got to be prepared to re-ring the bell if the appeal overturns the Texas court. Okay, is that confusing or what? So again, this is kind of what we just talked about. I just didn't get to the right slide there. Those are decisions to make. And again, if President-elect Trump actually went forward with the appeal, which would surprise most people, then we have an issue there. There's no indication that President-elect Trump would necessarily issue his own salary threshold increase. He didn't do that last time. The only thing he sort of has indicated he would be in favor of is perhaps a higher minimum wage, which would affect your hourly workers, perhaps, although most companies pay well above 7.25 already. Okay, the NLRB. Let's switch from the Department of Labor to the National Labor Relations Board. And most of you probably associate the NLRB with union stuff, and that is what they are most known for. However, their authority goes well beyond union issues. It really goes to any workplace type of organization or anything like that. In fact, one of the issues that would come up all the time when I was practicing is companies would have a policy that said, hey, workers, you're not allowed to discuss your bonuses or your wages or benefits or what you get from us or anything else. Salary and wages are considered a private matter. That's actually illegal under the National Labor Relations Act. Whether you're unionized or not, it's impermissible to prohibit employees from discussing the terms and conditions of their employment, including their wages, benefits, anything like that. And the NLRB enforces that even if you're non-unionized. So along the same lines, some states here had, within the last 4 years, passed what they call Worker Freedom of Speech Acts, which said, hey, employers, you cannot force your employees to attend certain meetings, what we call captive audience meetings. And Illinois, Connecticut, Hawaii, New York, and Oregon all had laws like that. And essentially it said, employers, you cannot have a mandatory meeting on religious or political matters or anything that involves unionization. So the religious one is kind of, it's so rare that an employer does that, that's kind of a non-starter. But political or unionization matters, or hey, we're all going to discuss why, we're the best employer and you shouldn't support a union or you shouldn't engage in collective organization, was a pretty common thing for employers who thought they were a threat of unionization to engage in, is to require a meeting where the employer would present its side of the story and say why they were good and that a union was not necessary. These laws went beyond saying, hey, you can't require the meeting. They said you can't even incentivize it. So like you can't give out a free lunch. Who doesn't like a free lunch? But they said, hey, giving a free lunch incentivizes this, or giving away gift cards or whatever it might be. So even though if the meeting is not mandatory, if you incentivize it, that's illegal too. So not surprisingly, we see a pendulum between the two parties when it comes to union stuff. Historically, and again, I don't take sides, the Democrats tend to be more pro-union than the Republicans. So somewhat not surprisingly, President Biden's NLRB weighed in on this on a national level about 2 weeks ago and said, hey, we agree with these states that already have the Worker Freedom of Speech Acts in place, and we're making this a rule on a national level for all employers. You can't force these types of meetings and you can't, quote unquote, incentivize them, even if they're not mandatory. Again, taking away the free lunch. Will this survive after the inauguration? A lot of people think no, but it's hard to tell. So be aware that right now, as things stand, you cannot force your employees into certain types of meetings or even incentivize them with the free lunch or the gift card raffle or whatever it might be to attend a meeting to say, rah, 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 we're a great employer, or we support this particular political cause or whatever it might be. Okay, moving on. The Pregnant Workers Fairness Act. So this slide just sort of goes over what it is. And we have a whole webinar on this when it came out in the regulations and all that good stuff. It applies to employers with 15 or more employees. There are some provisions that if you're an employer, you could view them as onerous. the fact that you can get very limited documentation. So if Ann Lavelle cruises in and says, hey, I have morning sickness, I need this accommodation, or I can only show up from 10 o'clock on because I'm so sick in the morning, or whatever it is, your ability to get information from my doctor is extremely limited. You sort of just have to take me at my word for a lot of accommodations that were considered automatic. If I wanted water, or if I wanted to sit down, or things like that. And the regulations also, and keep in mind, this is under the EEOC, the Equal Employment Opportunity Commission. So under President Biden's EEOC, the regulations were very broad, and a lot of people thought they went beyond the intent of Congress's law under the Pregnant Workers Fairness Act. For instance, one of the things was that 40 weeks of leave was almost always considered reasonable. It was an uphill battle for an employer to say 40 weeks of unpaid leave is unreasonable. And we also saw the EEOC making this an enforcement priority and saying, hey, we've got 2 lawsuits here in September for employers that failed to make pregnancy-related accommodations. What are we likely to see with President-elect Trump's EEOC? And I think this is kind of critical. It's likely a rollback of the regulations. So his pick for the lady who will be the chair of the EEOC has already taken issue with some of this and has indicated that she believes the regulations are too far-reaching. So while you won't see a repeal of the law, because that's a congressional law, and we can't do that absent a Congress repealing the law, which is not likely to happen, we're going to see the regulations very likely roll back. And so one of the issues that the lady who's going to be, or likely to be, the chair of the EEOC had was, hey, this is the Pregnant Workers Fairness Act, but the regulations cover everything that's sort of tangential to being pregnant. So abortions, which I recognize is a very sensitive topic, menopause, that's sort of the absence of being pregnant, just in case anybody needed that bio lesson. Infertility, sort of kind of related. And a lot of employers said, hey, this is so broad. It even covers stuff like, problems with your monthly cycle. Anything along those lines was covered under this, even though that might not have been the original congressional intent. The EEOC regulations were incredibly broad to cover medical conditions that were tangential to pregnancy. That's probably going to roll back if the EEOC chair has her way, and it will take time. It won't be automatic. Most people don't think we'll see any changes until 2026, just the way the EEOC works and how long it takes them to get revised regulations out and all that good stuff. In the meantime, you might see less enforcement on some of these tangential issues under the PWFA. And you might see more rights for employers to obtain information to prove, hey, Ann really is pregnant, she really does have morning sickness, or she really does need whatever accommodation I'm asking for. So we're likely to see a shift in the regulations under the PWFA, but not a wholesale rejection of the law. All right, this is also a hot button. And again, I don't take sides on any hot button issues. I'm the messenger, so don't shoot the messenger. So under President Biden's EEOC, they issued guidance, and guidance is not the same thing as a law or regulation. So this is an important distinction, first of all. Guidance merely says, hey, we the EEOC think we're going to interpret things this way. It's their idea of how they will interpret things. It does not have the same force or effect as a law or regulation. It's like a recommendation. Now, since it's coming from the EEOC, we always take their recommendations seriously because they are the ones who will look at a charge of discrimination or whatever it might be. Pardon me. One of the things they issued as guidance within the last year or two was they said, hey, an employer, if you have a situation where an employee is repeatedly misgendering, in other words, using the wrong pronoun or name, for somebody who has expressed a desire to be known by the other pronoun or name, then that's sex discrimination and you need to stop it. So if Ann Lavelle said, hey, I want to be known as Andy, and I always pick on myself, and please call me he, him from now on, and CTR insists on calling me Ann and saying, hey, she, Ann, is whatever, that in and of itself, the refusal to use the alternate name and the refusal to use the pronouns of my choice, right? I want to be him from now on, or them, or whatever it might be, was sex discrimination. President-elect Trump's pick for the EEOC chair has been very vocal about her public sort of opposition to this guidance. We're likely to see this roll back. And one of the reasons that she is against this, and you might say, well, hey, if Ann wants to be known as Andy, whatever, why would she be against this? She has said, hey, that can impede on other employees' freedom of speech and freedom of religion. So that's an interesting argument, although in private employers, I have no freedom of speech. Different story if I worked for the government, right? An employer cannot make me violate my religion. There may be an argument there. If I felt my religion required me to call me Ann and not Andy, because otherwise I'd be lying, and the arguments that are made along those lines, there might be a freedom of religion argument there. But she is against that. President-elect Trump is against this regulation, or this guidance, I should say. And so we're likely to see that turn back. Again, it's not like a first day thing. When he comes into office, he can't just sign, hey, get rid of the guidance. But we're likely to see this move more quickly than a reversal of the regulations under the PWFA, because guidance doesn't have the same force and effect as the regulations. So right now, misgendering, failing to call me Andy, and say he, him, if that's what I want, is actionable, and the EEOC will view that as sex discrimination. That may not be true 6 or 12 months from now. All right. Ta-da! This is either your opportunity for questions about anything you want to talk about, including the cold weather, or we can end early, and that's totally up to you. So I'm going to give it a few minutes, and if anybody has questions, great. For anybody who wants to hop off and start lunch early, I wish you the best of holidays and peace in the new year. So take care, everyone, and I'll just hang out here for a few seconds to see if anybody has questions. And again, I think they need to go in the chat. And if I've been crystal clear all year long with all the compliance things, then that's great too. Gosh, I must have been crystal clear. Okay. I'm just going to zoom to the end here in case anybody needs this contact information. Oh, I see somebody has raised a hand. Let me see if I can. Goodness, if you can put it into the chat, because again, I'm about as bad. Oh, wait, here's Q&A. Oh, okay, great. I'm sorry, the chat's disabled. The Q&A works. Yes, there's a reason why the technology group here does not let me do much with technology. Okay, so we are getting some questions. So what particular actions might take place with the NLRB with the Trump administration? So I think we'll see a rollback of the free speech, quote unquote, free speech type of stuff. The other thing is, historically, the NLRB under Trump has been a bit of a lame duck in the sense that they have not promoted rules and regulations that would help unions. And again, I don't take sides here. My husband's actually in a union. He's a teacher. Which if we don't get any more questions, I'll tell a funny story about that. But in any event, so we will see, whereas President Biden's administration and President Biden's NLRB promoted the idea of unions, and we saw some expansion of unionization, whereas we had seen a steady decline prior to that of the number of employers who were unionized. We're likely to see the NLRB not being active in terms of trying to increase the number of employers who are unionized. Okay, sorry about the chat is disabled. Okay, somebody else said none of this is a surprise. That's probably true. Given the history of the two parties, you kind of know what to expect. The problem is, and I always used to feel bad when I counseled employers, because we talked about the independent contractor issue last time. This pendulum just keeps swinging back and forth, and it's really hard to plan and predict whenever you get different parties in who take different views of things, and that's very difficult. All right, let me get over here to the other questions. And I apologize, I didn't know that it was Q&A and not the chat. I always get confused. Okay, somebody else said they're a new client. Hey, welcome. We do these, by the way, you do not have to be a client to attend these. If you have insomnia, you're also welcome to attend. But we do these for what I call friends and family. Anybody who wants to listen, who needs SHRM credit, who doesn't need SHRM credit, you're welcome to attend. It's 1 hour SHRM credit. The code gets sent out along with, by the way, all the slides and all that good stuff. It usually takes us about 24 hours to get it out. They don't let me do that because it's too far above my pay grade from a technical perspective, but they do send that out. So you all will get that. And if anybody has ideas for the future, please let me know. Happy to cover topics that people want. And there are topics that we have covered historically that have been of great interest, like the Allegheny County and Pittsburgh Sick Leave Acts. We have a whole webinar on that. That was one of our most popular this year. Same thing with the PWFA. We have lots of information on that as well in past webinars that we have done. All right, I am not going to beat a dead horse because I love horses and make everybody sit here because I don't want anybody to feel that they have to. If there are no other questions, again, have a wonderful holiday. Happy New Year, and may blessings and good things happen to all of you. Take care.